All about the money. Buckets and buckets, mountains of money, tons of cash going to the millennials as their parents pass on and step off, take their final celestial journey. Nancy Ling from FH&P is in our studios to talk about people who probably, possibly, hopefully might have an inheritance coming. Nancy Ling, the investment community is excited about this one. They have been for some time. As a matter of fact, I heard stories about the greatest fleecing of the lambs that has ever taken place. That, of course, was the big banking scandal in the United States, as unscrupulous fiscal organizations leaped out and effectively raped their clients and their customers. And as the money disappeared, the inheritance disappeared, destitution fell upon the shoulders of so many people. We want to make sure that doesn't happen today, right?
Right.
All right. So where are we going? I've been notified that a long lost uncle who apparently liked me better than I liked him has decided he wants to leave me $25,000. I haven't even talked to him in the last 10 years, and now he's dead. So $25,000 is coming my way. What am I going to do?
Right. I wanted to give a bit of information on that because I often get people come in with questions about this. They've just received the notice in the mail, and they've got no idea what it means. Of course, it's full of a lot of legalese, and they think they maybe have to do something if they're going to claim the inheritance. And then, of course, there's all the fake ones floating around out there if you're expecting $30 million from Nigeria. The Nigeria. If we'll just give him if we'll just give him my bank account, he'll transfer the money in there, and Bob's your uncle. Right. So, piece of information number one: you'll never have to pay the executor to receive your inheritance. So, unless you've borrowed money from the estate, that's a different story.
Right.
But so you get this notice in the mail, and it's really just advising you that the executor has a will, and they're going to apply to probate it, and so they have to go through that whole process before you can get your money. So the first step in applying to probate a will is you have to give notice to all the people named in the will and all the children and spouses of the deceased, letting them know that this is the will that you have and this is the one you're going to probate.
So not only the prime beneficiaries, the people that are actually named, but you also have to talk to their children and their, sort of the substrata, if you will?
Right.
You have to go down the family chain?
You've got to give notice to people that would be entitled to inherit if this will didn't exist. So if this will was a fraud or a fake or if it had been revoked or something like that.
Okay.
So the people that would inherit on an intestacy, meaning there is no will, are the spouse, the children. So you have to make sure that you notify them, the people that would inherit if this wasn't a valid will, as well as the people named in the will that will inherit. So if you get this notice and you know that this isn't a valid will, or you know that this isn't the most recent will, or anything is wrong with it.
Or even you believe,
right,
as opposed to know.
Well, then it's a good idea to maybe talk to a lawyer to see what your options are. But that's your heads up that this is the will that's being probated. And so if you've got knowledge or information that it's not the right one, you need to let the executor know. If you don't, 21 days after they mail out that notice, they can go and start the probate process of getting this will with the seal approval of the court deemed valid. And later on, it's going to be a lot harder to get that. Well,
hold on a second here. If it's already been done, is a little too late.
It's a little more expensive. There's more hoops to jump through if you want to unravel a probated will or have it proved in solemn for. There's more steps through the court system, if you will. If you don't notify them right away, wait, don't probate that 2009 will. I've got a 2013 will. Right? So that's your first heads up to do it. But if you don't have any reason, if you look at the will and you think it's the valid will and you think it's all good, then you don't have to do anything. You just have to sort of keep half an eye on the executor if you think there's any possibility that they might do something offside. Because at the end of the day, the estate is being administered for the benefit of the beneficiaries, the people that are inheriting under the will. So the executor is in a trust position. They're a fiduciary, meaning that everything that they're doing for your benefit. So sometimes we run into problems between the beneficiaries and the executor. And it's a lot of stuff to do with the timing of the estate, which is why I wanted to talk about this. Sometimes it's the executor that's in the wrong. Sometimes it's the beneficiaries in the wrong. They're calling every week, where's my money, right? They want to know every step that's happening. And they end up increasing the legal fees because the lawyers, the executor, have to take more steps to deal with these anxious beneficiaries than they otherwise would have.
Take me to the situation, however, where a long-lost uncle who I haven't talked to in the last 5 years dies and apparently has left me $25,000. He has 3 kids. They don't like the idea that 7 years ago, Uncle George and I were on a trip, and I helped Uncle George do this, and I helped Uncle George do that, and for whatever reason, he's never forgotten it. And in his final thoughts about who he's going to leave some money to as he steps off the earth, decides that, you know what, he's a pretty good kid. I'm going to leave him $25,000. What do you do with his kids who say, there's no way that we like this idea?
Right. So that's another reason why there's a bit of a delay before you get your money, because once the will is probated, so that means that the executor has taken the will, they've given a list of the assets to the court, they've notified all the beneficiaries, and they're waiting for the court to review the will. Once you get probate, there's a 6-month window where a spouse or a child of the deceased can apply to vary that will because they don't think it's fair.
They want to vary it?
Vary it. So if
they want to change it.
They want to change it. They don't think it's fair. They don't think it adequately provides for them. And the people in BC that are entitled to be provided for are spouses and children. So those are the only 2 classes of people that have a right to say, yeah, sure, this is a valid will. I just don't think it's fair. So if you are the long-lost nephew, you don't have that standing to vary it because it's not fair, but you are a beneficiary because the testator, the deceased, wanted you to be.
What does the fight for your $25 or $25,000 look like then?
Well, if they bring a application to vary the will, they've got to prove that it isn't just reasonable distribution. There's factors that go into it. You know, was there an estrangement? Was the person, the deceased, were they suffering from any delusions about this relationship? Were they acting on misinformation, things like that? Why were the kids disinherited? Or why is their share not fair? Did the kids work on the family farm for their entire lives and now they're being cut out, right? So every circumstance is different. They're all very fact specific. But the nephew, for instance, if he knows why the kids were disinherited or he knows why the uncle left him this money, he can put forward evidence to support why it was a reasonable choice, right?
And ultimately, it falls to a judge to make a final determination.
If it gets that far, if it gets to court, the judge will look at all the facts and will make a decision. Otherwise, you might come to a settlement with the kids. Say, listen, I don't want to go to court. I just want my money. I got a mortgage to pay. I've got whatever to pay. How about I just take $15,000 and we call it a day? You know, so there's a couple of different options there. And the kids, they'll probably try the spaghetti at the wall approach, right? They won't just apply to vary the will. They might
like mud on the wall better. Right? Throw some mud on the wall, see if it sticks.
Yeah. So they'll claim that the will isn't fair and it should provide more for them. But they'll probably also claim that there was some undue influence, or maybe there was some problem with the technical signing of the will. It's not valid, or the will maker didn't have the mental capacity to make the will when he did. He was somehow being forced to do it or wasn't in his right mind when he did it. So they may try that approach too if they think that the nephew did something nefarious to sort of orchestrate this.
And is this long and protracted? Does this take a long time? It sounds to me like there's a lot of exchange of paper and letters and sit down and consult with, and so documents get written, and then we present our side, they present their side long before it goes to the judge.
Right. So there's that 6-month window that I was talking about, the limitation period where a spouse or a child can bring the will's variation application. So that 6 months begins to run from the day probate is granted. So if the nephew just wants to sit back and wait for that 6 months to expire, assuming that the kids were given notice that this will was being probated, then once that 6 months is up, their will's variation window is up. So then the nephew can take his money and he's good. But if they do start an action within that 6-month period, then you're dealing with a court process. And if anybody has been involved in a trial before, they know that it's not a quick process. You start with the exchange of the letters and your statement of what your facts are and what your argument is, and then there may be settlement attempts and mediation attempts, any of these things. But if you do end up going to trial, you've got to book a trial date, and that can sometimes be a year down the road.
These days it's backed up like crazy.
And there might be applications in there before trial. Maybe you don't think you've been given all the evidence. Maybe you don't think the other side is following the court rules. Maybe you need witnesses, things like that. So
this was just $25,000 that I was absolutely surprised like crazy that I get this notice that says that Uncle George, who I haven't seen in 5 years, obviously has never forgotten that time that I helped him out do whatever, and he remembered me and the $25,000 is coming my way. I thought I was just going to get $25,000, pay some sort of a transfer fee, and then I was going to go away with the money. You're making this really difficult, girl.
Well, it's up to you how far you want to go with it. You, as a beneficiary, it's a good idea to touch base with the executor to find out if any of this is going on, if anybody is contesting the will.
Yep.
But you don't really have to do anything if you're not interested in it, right? If you want to just let them fight over it and see how it plays out, and you can do that. If you have evidence that the judge should be considering, you may want to consult a lawyer and make sure your evidence gets in front of the judge, but you don't have to do anything.
All right. Going to take a break on this Tuesday morning. It's our Tuesday morning law talk. Nancy Ling from FH&P Lawyers is here. If anything that we've been saying resonates with you, strikes a familiar note, love to hear from you. 250-862-2525. If you have questions about wills, estates, if you have questions about that inheritance, if you have questions about how hard you're going to have to fight to get it, or can you just sit back and let the circumstances play out through a course of events? What do you have to do to collect your inheritance? Free legal advice, FH&P, Nancy Ling. We'll be back in a moment. We are talking with Nancy Ling from FH&P Lawyers. We're talking about the greatest transfer of wealth in the history of the world as millennials are about to receive trillions of dollars coming their way from their parents as they step off the earth on their final celestial journey. And so we are talking about those notifications that suddenly arrive in the mail, suggesting that you have an inheritance coming, whether it's from an immediate family member or maybe somebody far more distant. Nancy Lee, what does this look like, and what kind of paperwork so that people know what they're dealing with?
So it's going to start with a court form, which aren't necessarily the easiest to read. It's called a P1 notice. All the probate forms start with a P. And it's called a notice of intention to apply for estate grant. So really, this is them, the executor, giving you notice, as we talked about before. But you'll get that P1 notice, which is, it's got a bunch of legalese in it, and also a copy of the will. You should have both of these things, unless there is no will and they're applying to get administration of the estate. But if you have questions about...
So you should receive a copy of the will?
You should, yes.
If your name is somewhere in that document, you should receive a copy of it?
Yes.
Okay.
So we actually do get quite a lot of calls and questions about that because people are demanding copies of the will and they haven't been given one. That's usually an indication that they weren't in the will. If they're a child or a spouse, they should be receiving it regardless. So if you're a spouse and you're not receiving it, that can be an indication that someone's taking the position that you weren't a spouse, right? If you were never married and you were common law, they might try to argue that you weren't actually common law. So it's a good idea if you're trying to get a copy of the will and it's not forthcoming, might be a good idea to talk to a lawyer, especially if you're a spouse. But this P1 notice, you'll get it. It's about a page and a half. It basically says that the person named in it, so, John Smith has got a copy of the attached will, or the original attached will, and he's going to apply to probate it. You've got 21 days from the day that this is mailed out before he's allowed to do so. So if you have another will, let them know right away. It'll also have some information about the Wills Variation Act. If you're a spouse or a child, you have the right to vary, things like that. So it is helpful if you want to understand what this notice says. You can call our office. We'll go through it with you. If you're not concerned about it, if the will, names you as the sole beneficiary and you're about to inherit $1 million and you're not all that concerned about it and you trust the executor, right, then you can just sit back and wait for the probate to happen. The executor...
Let the course of action as prescribed just roll.
Yeah. I mean, it's not
like this hasn't been done before.
Right. And if everything is done correctly, then within about a year, you should have your inheritance. Unfortunately, it's not a quick process, so people get antsy and they start to wonder what's happening. The executor's got a duty to account to the beneficiaries. They're accountable to the beneficiaries because it's their money that is being dealt with. So if you think that they're spending too much or if they're not realizing the assets properly or the assets are in danger or, they're letting their best buddy live in the house rent-free, those sorts of things, then you should call the executor on it or hire a lawyer to call the executor on it. You can force the executor to do what's called a passing of accounts. So how much money are you entrusted with? What have you been doing with it? How much is left? what's the holdup, right? So
how much money was there? How much is left? What the hell have you been doing?
So, right, if the executors have done something wrong in administering the estate, they can be held personally accountable, right? So if they're entitled to be paid remuneration and reimbursed for costs that they have to pay out of pocket to administer the estate. But if they're taking too much, if they're taking more than they're entitled to, at the end of the day, the beneficiaries have got to sign off on that. So you're entitled to see what they've done and consent to it at the end of the day. If you don't consent, then it's a judge that looks over all of the accounting.
Does the Law Society protect the individual at all?
The executor?
No, protect the person who is the recipient, the beneficiary, where you think you're being treated unfairly, where you think that there might be something funny happening with the lawyer, something happening with the executor. Are you protected by the Law Society?
You're always protected by the Law Society if you think a lawyer is doing something wrong.
Right. Okay.
So the Law Society is the governing body that governs
of the legal
lawyers,
profession.
Right. So if a lawyer is stealing money or committing a fraud or something like that, yeah, you can report them to the Law Society, and the Law Society will step in. But if it's between you and the executor, the lawyer most likely just represents the executor. They're helping the executor through the court process and advising them on their role, responsibilities, obligations. So then in that case, the lawyer is probably just moving it along. If the executor is doing something wrong, the lawyer may or may not know about it. If the lawyer does know about it, then there might be an issue there.
It's funny what money does to people, though.
Yeah.
Especially big amounts of money cause really crazy character shifts.
Right.
And people you believed in, people you trusted, people you honored, respected, have suddenly become somebody you don't even recognize.
Well, it's a good idea to think carefully, and I think we've talked about this in the past, but think carefully about who you do choose as an executor. Think about who your beneficiaries are and who the executor is, because there's the potential for a power trip there too, right? The executor is controlling the whole process. They're driving the bus until they get to the point where the 6-month limitation period is up. They've got all the money. They're ready to distribute. They can delay that. They can play games. They can make the beneficiaries wait longer than they should have to.
Sound like a plot out of a bad a B-grade movie.
Yeah, I've seen some strange behaviors, if it's one of the siblings is named executor and they're lording it over their other siblings. And vice versa. I've seen executors that are mourning. They're doing a very difficult job. Maybe they have to wind up dad's company. Maybe they've got to track down assets all across the world. And they're being harassed by the beneficiaries. So I've seen both sides of the coin. I've seen the executors where they're not in any hurry to wrap up the estate because they're living in this mansion while they do it, which they're not necessarily entitled to, depending on what the will says. But, they're, I've listed the house for sale. It's just not selling. Well, maybe they're not really looking at any of the offers. Or maybe the executor intends to buy the house themselves, and so they're trying to pretend the market value is lower, or they're ignoring offers. So there's all sorts of things that can go wrong, which is why these things occasionally end up in litigation. But it's an interesting dynamic, and the way that it affects some people has some interesting results.
Nancy Ling from FH&P. Is there anywhere else we need to go?
Unless people have questions, I really just wanted to make sure people knew what the process was and how long it can take. We've got this standard term called the executor's year. So if you did get this notice, don't start buying a car or something or a house. You're going to have to wait a while until you actually get that money.
Do people do that?
Some people do. They know they have an inheritance coming, and they start spending it before,
levering it,
counting their chickens.
Do you take the legal notification with you to the car dealer and say, "Listen, it says I got $1 million coming here"?
But they also won't know how much. The P1 notice doesn't tell you how much, and the executors will file a list of assets when they do file for probate. So it'll say there's a house, and this is the fair market value. There were these bank accounts, this is the fair market value. A boat, etc. So you could request a copy of that if you wanted to know what the value of the estate was. But usually you're not going to find out what you're actually getting until the end of the line, until they've collected all the assets, paid all the debts, filed the taxes with CRA. Sometimes that process will take 6 months. And then paid the legal fees, paid the accountant fees, paid the executor's fees, and then you know what you're getting. So
wow.
you might not
the
actually
person,
know.
The person to whom the money should be falling is a long way down on the pecking order.
Yeah, you get paid last.
All right. Very quickly, we always try to take our phone calls, and Betty is on the line. Betty, good morning.
Good morning. I'm a little confused about the timing. Nancy mentioned 21 days. No, that was for the probate. I'm a little confused. I received the notice with the will and whatnot January the 10th. Then it wasn't, and I had trouble getting a lawyer. And everyone was so busy. Then when I did, they sent the letter, and I just don't have the date here, but in February. And now I'm getting a letter. Please be advised, our office does not handle litigation matters. As such, we are instructed to continue with the application for probate, but we'll be referring our client to an estate litigation lawyer. And so they're going ahead with probate, and earlier you said it could make it longer and more costly.
Have you launched the litigation? Or did somebody else launch the litigation?
I did.
Okay, you did.
Yes.
Right. So
well, with the lawyer, she notified the estate, but now in between, I'm just wondering about the timing of it. If they go ahead with probate, like they say they're going to.
Right. So probate, there's the 21 days they have to wait after you get notice, and then they have to, apart from that, collect all the information about the assets. So they're going to be writing to banks, trying to find all of the deceased assets, if there's any difficulties with that, life insurance, etc.
I supplied all that information to them like
so,
a dummy, and so they're ready, apparently, to go to probate.
Okay, so once they've got all the information together that they need for their application, and it's all prepared, they swear all their affidavits saying these are all the assets. They file it with the court registry, and then it's in the court registry's hands, depending on their workload, for how long it takes to do a grant. If it's uncontested and there's no issues and there's no litigation, the probate registry might get it done in 6 weeks to 2 months when the grant is ready. And that's when the 6-month limitation period starts to run. So we're talking about 3 months in now, and then you've got to wait another 6 months for the limitation period to expire. If litigation is started in that window, all bets are off. You don't move until the litigation is settled.
I guess the question I have is the litigation part. All my lawyer has done is send a letter that it will be coming.
Well,
and they're saying, we can't handle it, we're going to pass it on, but they're going to go ahead with probate.
Right. Well, I would talk to your lawyer about what your strategy is, what the steps are in your matter specifically. But what it sounds like the other lawyer might be saying is they're only dealing with the administration of the estate, and they're not going to be defending any litigation. They're acting neutral.
Yes.
So I would give a call to your lawyer and ask them to set out what the steps are for you.
Very good. Thank you. It's been interesting this morning.
Listen, here's an idea, and I know that Nancy always never refuses a phone call. If you want to contact her directly, just go to FH&P Lawyers on the web, and if you don't have access to the web through a computer, if you've got a pencil handy, I will give you her direct line.
Okay, I have a pen handy.
It is 448 0527 with 250 in the front of it.
Okay, try it one more time.
448 0527.
Thank you so much. Very good.
Always good to help. Thank you.
Thank you.
Appreciate it very much. It's complex.
Mm-hmm.
And you know what? And with apologies to Betty, I think she's doing a marvelous job of trying to stay on top of this. But I also think she needs a guide.
Right.
I think she needs someone to take her by the hand. for any of us. Sometimes this stuff just sort of arrives in the middle of your lap. You read the thing 3 times. It feels like it's Greek to me.
Yeah.
It doesn't flow smoothly. It's loaded with legalese. And I feel like I'm being victimized by the legal department.
It's a very complex area of law, estates, and there's a lot of overlapping factors and considerations there. For example, with the call that we just had, the one role there as executor or as the lawyer for the estate, they're really just doing a job of trying to get this will probated because it needs to be probated before they can liquidate estate assets, move ahead, right? The executor sometimes will end up wearing 2 hats. So if it's a spouse or an oldest child or something like that, they might be the executor, but they also might be one of the beneficiaries. So technically speaking, executors have got a duty to not self-deal and act in the best interest of all beneficiaries. So they've got to act neutral if there's litigation that comes up, even if themselves as beneficiary might have a vested interest in fighting the litigation.
No kidding.
So in that situation, usually the executors will hire a different lawyer because they don't want to confuse
So there's
the two.
no conflict.
Right. So they're not confusing their role as executor with their interest as beneficiary.
Yeah. Better to have that outside independent body, keeps you free and clear, removes anybody's ability to allege impropriety.
Right. So they're not saying that you as executor are, blockading this litigation because you've got a vested interest as beneficiary. As you as executor, you're, being neutral. You're just providing information that the court needs to make a decision. But you as beneficiary, you can go in there and fight tooth and nail, right? If that's what you want to do. But you have to make sure you understand what the different roles are, especially if it's the same person.
Look at Martha. I got money here too. All I want is my money. You want your money, and I'm trying to work on both our behalves to get this settled as quick as possible. There's 7 other people out there with their hands out that all say that they have a piece of this pie that should be coming their way. And quite frankly, I'm not equipped to do this.
Yeah, you have to think very carefully about whether you want to accept the role as executor. So think carefully as a will maker about who you want to name. And then if you find out you're named as an executor, think very carefully about whether you want the job.
All right. Back to the phones. Billy has a quick question. Good morning to you.
Good morning.
Yes, sir.
Yes, good morning, ma'am. So correct me if I'm wrong. So if you get something from a bank and it's not a P1, is that a scam?
Sorry.
If you get something from a bank and it's not a P1 form, are you being scammed?
I guess it depends on what it says.
Well, a long lost if you want to use your story, a long lost relative has and you say same last name, and it says you have so and so much waiting, for lack of better words. Is that a scam? That's not a P1.
It's a good idea to get it looked at, right? So bring it by the office. We can take a look at it. Let you know that one of the key factors is, are they asking you to do anything? Are they asking for your personal information? Are they asking for money?
No.
So they're just letting you know that you've got money coming?
No, it's being held, but if you want to use those words.
And what does the letter ask you to do about it?
Get in touch with the person who's got in charge of the money.
Yeah, so it might be a good idea to, call up the firm and ask a couple questions. We can run through some names and look at the letter for you, and we can look at some of the initial indicia of whether it is a scam. And the Law Society is always alerting us about the scams that are out there. So it might be a good idea to get some advice on this.
Thank you, ma'am.
All right, thank you. Good call. We have to take a break. We're running against the clock here. We've got a call on hold. Addie, you'll be first up when we come back after the break with Nancy Ling from FH&P Lawyers. As we talk law and wills and inheritance and something called a P1 notice and beneficiaries and how to collect your money. Back in a moment. Tuesday morning law talk. We are privileged to have Nancy Ling from FH&P Lawyers in our studios. Wills, inheritance, estates, definitely the area of law that she works in, practices in frequently. And so addressing questions on the process of probate and what happens if you suspect the executor is maybe behaving in an untoward manner, something called a P1. And we'll go back to the phones now. Addie, good morning.
Good morning. How are you?
Good morning. Thanks for joining us.
Interesting subject. I'm wondering what would happen if let's say you've got 8 grandchildren and you have an RRSP and you want that RRSP to go to the grandchildren. Does it have to go into the will, or can it just be upon your death be split?
Yeah, it doesn't have to go through your will. You can name them as designated beneficiaries, and then it will go directly to them and won't have to go through your will and this whole probate process.
So what happens then with the taxes? Do they get taxed on it? Does my estate get taxed on it? How does that work?
The starting point is that your estate gets taxed on it. If there's no money in your estate, CRA is one of those super creditors that can follow the money. So if there is no money in the estate, they might go to the beneficiaries for their share of the taxes. But if there is money in the estate pays that bill.
Okay, so what you're saying that if there isn't enough money in the estate, then I mean, you never know what's going to happen in the meantime, sort of thing. So let's say I've got $200,000 in the estate, and I've allotted it to these 8 grandchildren, but then I'm also sort of using that money if I need it.
Right. So
if there's no money in it's like if there isn't enough money to split it evenly, they will go to the children for the taxes.
The first thing that comes out of an estate is the debts. So any unpaid debts, whether it's a mortgage or credit card bills, whatever, but also your taxes payable to CRA. So including the taxes on RRSPs that get paid outside of the estate. So once all of the debts and taxes are paid, then what's left over from that $200,000 will go according to your will. Any accounts with designated beneficiaries like tax-free savings, RRSPs, or life insurance with designated beneficiaries, those go outside the will directly to the beneficiaries.
Okay, super. Great. Thank you very much.
Mm-hmm.
Good to talk to you. Thank you. I've got an email now. Phil, can you please have Nancy go through the process involved in settling the estate? I'm busy working at my desk, and the phone keeps ringing, and I keep losing track of some of the things that she's been saying.
Okay.
Here's the case. We have filed probate documents in early January. Once that's done, then there's a 6-month waiting period for any litigation. What is the process after that?
Okay, so you've got the grant to probate, the 6-month limitation period starts. If all beneficiaries are all on side and they're all happy and you know what the debts are and you've paid them all and you're good to go, all beneficiaries can consent to wind things up before that 6-month period. They say, we're not going to start a lawsuit. We're releasing the executor. Let's just cut checks. They can consent to an early distribution, but they have to sign that in writing. If they don't, and you want to wait for that 6-month period, you also have to make sure that you pay the final tax bill. So if you get the help of an accountant, you can decide whether you know what the taxes are going to be, or you can ask for a clearance certificate from Canada Revenue. That's where they say, yep, you're good. All taxes are paid. We're not going to come back and reassess. Once you apply for that clearance certificate, that can take 6 months as well. So it's a good idea to talk to an accountant to figure out what's going to happen with taxes. The other option might be that you hold back a certain amount. So say, the $200,000 we're talking about, you talk to an accountant, you say, the most of the taxes are going to be is this much. Let's hold back $50,000.
Right.
Then all the beneficiaries can split up the $150,000 and you wait to pay out that last.
You get a second
50,000.
check when the expenses against it are taken.
You do an interim distribution of the majority of it, but you hold back a certain amount just in case there's a final tax bill.
Why 6 months to get a clearance certificate?
That's just the timeline, the workload,
the bureaucracy,
what it's taking. Yeah, it might be faster now. I don't know. I think the last one was around 6 months, but
right.
That's just sort of how long it takes to deal with some of these government bodies. So yeah, once you've got all of that done, you're doing the final distribution. Every last penny is being paid out of the estate. Usually you want all the beneficiaries to sign off, approve of the account. So the executor does an accounting of what they're being paid and what we said, what you started with, what's left. And then ideally you get them to sign a release saying, we agree, this is what we're getting. You've done your job properly. We're not going to come back and hold anything against you. And then you're done.
Nancy Ling, fascinating. As a couple of callers have said, this has been a good one, and I want to thank you very much for being here this morning.
My pleasure.
Truly a pleasure to have you in our studio as well. Nancy Ling can be found at FH&P. She answers her direct line. You can leave her a message at 250-448-0527. The better thing to do is go to Google and type in FHP lawyers, and it'll get you to the masthead for the company, and you can scroll down and find Nancy Ling among the lawyers who are working there, specializing in inheritance, estates, wills, and so on and so forth. Does other law as well, but a lot of this kind of practice falls to her. I want to thank you very much for being in the studio.
Thanks for having me.
All right, thank you.